About how coercion plays out in the Supreme Court precedent. So, I mean, it's a very specific question, and it has specific consequences, I think, in the case. Our whole point is this is a passive display. The argument they're trying to make is that it is, in fact, coercive. We don't think that it is. We also think that coercion in the context of Supreme Court precedent has a very specific meaning, and this is not it.
You do expect this to go to the Supreme Court, correct?
I'm sure that if we are successful here at the Fifth Circuit, that they will file a cert petition in the United States Supreme Court. Now, what the United States Supreme Court will do with that is anybody's guess.
I'd like to make a comment about that. You know, it's interesting. When Liz and I went to school, we always hoped that our moms might, or certainly I did, would put a quarter or a dime or give us a little money to maybe get a snack after school. What's amazing to me is on those coins, on our currency, is in God we trust. And yet we would put that inside, we would put that inside of our pockets on a consistent basis. So we spent more time with money in our pockets than we spent in school, right? And yet I don't understand, again, why we are here, why we can't just embrace the historical and traditional concepts of the Judeo-Christian principles that this nation was founded upon.
And to that point, there was a lot of discussion about examples that came from the bench about other documents that invoke God, invoke religion, invoke our traditional principles upon which this country is founded, religious principles upon which this country was founded. The point that we are trying to make is that this is a foundational document for our legal and our historical traditions in creating our government structures, creating our country. The beliefs upon which it was founded are embodied in these documents, and they are illustrated in places as vaunted as the frieze in the United States Supreme Court, among others. And we illustrate that through those posters that we created, including quotations from Justice Ginsburg in her own book, which, interestingly, were dismissed as the musings of just an eighth grader. Well, she wasn't just any eighth grader. She was an eighth grader who became a Supreme Court justice who never repudiated that particular statement. In fact, she put it in her book. So, I think that's one of the reasons we selected it, to illustrate how this is not only foundational, but it is instructional as a document for our children to learn, is part of our historical foundation.
Katie Royce with CBS News. Question for you. I mean, if this case does go to the Supreme Court, it could have a significant weight in setting a new precedent in terms of, changing separation of church and state foundations that this country was founded on. How do you hope that this state law may change, precedent for other states around the country?
So, two things. One, we think it fits squarely within Supreme Court precedent. At the end of the day, our law, we believe that we've illustrated how it does that by creating posters that illustrate that. And so I don't think that it really does change anything. I think that we should be able to allow this document to be posted in the historical context that we've created it. There's a larger question in play here about how and when you should be able to challenge state laws and what the burden of proof is for somebody to take down a state law. And that's a lot of what we were talking about in there, is that this is premature. So, I think that will play out in this case, too, quite a bit.
Can you say more? Can you say to parents who say that these commandments, this specific version of them is not their family's religion, it's not what they would teach their children, and it goes against their right to control their children's upbringing?
It's not establishing a particular religion. It's not establishing a particular selection. It's not establishing anything. It is presenting an ideal of the foundational document of one of the foundational lawgivers that is part of our historical tradition. So, and it does that in a historical context in all of the posters that we've created. So, I think that it is not coercive in that sense. It is posted on a wall. Nobody, and I think Judge Duncan pointed that out in one of the distinctions that he made regarding one of the cases, where the requirement was for a teacher to direct and state something in particular to a student who expressed a particular opinion that was contrary to the opinion that was in the books. And nobody's directed any teachers to say or do anything in this context, which I think is important.
I would advise parents like that they find some moral code. You either read the Ten Commandments or your child is going to learn the criminal code.
Do you think any other states will follow through if you guys do when moving forward?
Well, Texas did. So, that's why they're here with us, because they did. And, I think that, yes, maybe some other states would, and I don't think that's a bad thing. I think that's a good thing.
Do you see any limits on what could be in a classroom? Whether that was part of the discussion, could there be certain prayers or certain Bible required readings? Is there any limits?
Sure, there's limits, and the Supreme Court's delineated those limits, and so I think that's part of the discussion that we had today, is where those limits exist now inside the boundaries that have already been established by the Supreme Court. So yes, there are limits. We think we're inside the limits.
And then I have an off-topic question. Julia Letlow, she was endorsed by President Trump. What are y'all's thoughts on this?
She's a great friend, and I think she'd make a great United States Senator.
Governor?
Yeah, I think the Attorney General said it best. I'll rest my case.
Usually one more off topic for you. On your trip to Greenland for the Dog Sledding Association race, has that been canceled?
Yeah, look, we're still working through that. I mean, I've seen some of the reports of those that are saying, look, it's been disinvited. It's certainly, if that is true and what exactly is going on, and that's certainly disappointing. I don't think we would reject Greenlanders to come to New Orleans for the Super Bowl, right? I mean, this is about hospitality. This is about having a discussion. This is what it's always been about. And so, again, a better question would be to ask those that are saying that if they would like, if the United States would disinvite them to go watch the national championship that happened last night, or the Super Bowl, or the college, or the Final Four, or any of the other great sporting events that we have. In fact, every time I've checked, people from Greenland were looking for ways under which they could expand their tourism and visitations to Greenland to help prop up their economy. So again, all Greenlanders, in my opinion, are invited to New Orleans to come and share the great tourism and the food and the great events that we have here, and I would expect them to have the same for us as well. Thank you.
Any final question on the Ten Commandments? Are we good?
I think we're good.
Okay.
Thank you guys so much.
Yes. Thank you.
Thank you. You guys want to go ahead and take it?
I'll give a comment from another organization involved if that works for you.
I have to get my thing. Hold on.
Of course, yeah. Good afternoon, everybody. My name is Joe Davis, and I'm counsel at the Beckett Fund for Religious Liberty. We're an organization that protects religious freedom for all people of all faiths, and we're helping Louisiana defend its law, defend against its law, which provides for the Ten Commandments to be displayed to Louisiana students. As the Supreme Court has very clearly said, the Ten Commandments are a foundation of American law. They're among the foundations of American law, and if that's the case, we should fully expect that Louisiana might want its students to know about them. As Governor Landry and Attorney General Murrill said just now, symbols featuring religious imagery have been a fixture of American life since before the founding. From the founders' own proposals to the national seal, which represents the country as a whole, to Ten Commandments, which are on the walls of the Supreme Court, of course. Our nation has long included this sort of symbolism, this sort of passive, non-coercive symbolism in its public spaces. No one has ever thought that that was an establishment of religion, and that is the question in this case. Is that an establishment of religion? The answer is no. Students are free to learn about the Ten Commandments if they would like. They're also free to ignore the posters if they'd like and go about the rest of their classroom instruction, and that's how passive displays are in general. So with that, we're optimistic that the Fifth Circuit will uphold the law in this case and say that this is not an establishment of religion as the founders would have understood that term. Thank you.
Thank you so much. Okay, actually, do you mind giving us your name and spelling it for us?
Of course.
So we have it for the record.
Joe Davis, Joedavis.
Perfect. Thank you.
Jonathan Youngwood for the plaintiffs. We're very pleased with how the argument went.
judges were very receptive to their different arguments. It was obviously vigorous, and the questions were pointed to both sides. We were pleased with the reception we got, and we're looking forward to the court's ruling.
Hi, I'm Dan Mack from the ACLU. We were here today to defend the fundamental religious liberty of students and families in public schools. We have a group of 24 plaintiffs from a variety of faith backgrounds, Presbyterians, Baptists, Jews, Hindus, Unitarians, atheists, non-religious folks, and we also have several rabbis and ministers. All of them are concerned families, and all of them share one single important belief, which is that it's up to these families and not the government to direct the religious education of their kids. And that is something that's enshrined in the Constitution, and it is something that the U.S. Supreme Court has repeated over and over again, including in the context of laws just like these, which require the posting of religious scripture, the state's preferred selected religious scripture, every day, every hour, every class, every year of these students' lives. That is religiously coercive, it's un-American, and it's unconstitutional.
Hi everyone, my name is Rachel Lazar. I'm the president and CEO of Americans United for Separation of Church and State, and I'm here to say that our Constitution promises the separation of religion and government, and that this law requiring the posting of the Ten Commandments in public school classrooms, which are government run, is a violation of that promise of church-state separation. It's unconstitutional, it's un-American. That's point number one. Point number two, we're talking about children and families. That's who's at stake here. And I appreciated your question earlier. We represent families from all different religious backgrounds, and they're the ones who are telling us that their children are going to feel uncomfortable and be taught a religion that isn't their families. And one of the things that Americans we disagree on a lot of things, but here's what we found. Americans agree that parents should be teaching their family's religion to their kids, and Sunday schools and faith leaders, not government officials or public schools. And that's what's at stake here. And number three, it's time for a national recommitment to church-state separation before it's too late. What do I mean by too late? What I mean is our freedom to live as ourselves and believe as we choose relies on the separation of church and state. And so does the peace in our country, because we live in a pluralistic democracy with people of all faiths and none. And our founders were wise to know that it keeps the peace and unites us to separate religion and government. And right now we're at risk of being the most divided our country has been. And one of the reasons is because of this kind of undermining of church-state separation. Thank you. Any questions for us?
I'm curious, same question that I asked the AG. I mean, how do you see this law as being a slippery slope for the eradication of church and state?
I mean, I can start, and John, if you want to come in. It's a clear violation, as the Fifth Circuit, by the way, already said, because when you have a public school, which is a government-run school, preferring one set of religious beliefs over others, and this whole nonsense about this isn't actually religious. Firstly, that's an insult to religion, right? I mean, I'm Jewish, right, and I venerate the Ten Commandments, but my form of the Ten Commandments, and please don't tell me that it's not a religious doctrine. And for the non-religious, right, or for Hindus or religions that believe in multiple gods, what is the first commandment, right? I am the Lord thy God. Thou shalt have no other gods before me, right? That is religious. So this is about as basic a violation of church-state separation as they come. What comes next? Well, we already see on the list is to fully fund Christian or religious public schools. That's one of the things coming next. John, do you want to add to that?
The Supreme Court has been extremely clear that you cannot do what these two acts do, which is post the Ten Commandments in schools. It's a case that's 45 years old. Nothing has disturbed it. And these legislations were designed specifically to disrupt that precedent. And if successful, we'll move on to other precedents, such as recitation over the loudspeaker of Bible verses, prayer at football games, prayer at graduation ceremonies. That is the concern, but the concern starts with just this case, and this case is clearly controlled by Supreme Court precedent.
Hi everyone, my name is Alana Odoms. I'm the Executive Director of the ACLU of Louisiana. And our affiliate has been working very diligently over the last several years since this piece of legislation was passed to hear the voices of parents and families in the state of Louisiana. I am a mother of a school-age child, a 6th grade child here in New Orleans. And as a mother and as a person who practices a Christian faith, I personally have very strong views about this piece of legislation and this act, but I've also heard the voices of other parents of children of various faiths who feel threatened by the fact that our state would in fact privilege Christian religion, and in fact a Protestant interpretation of the Ten Commandments over other religions. That is invasive to children, and the Supreme Court squarely views schools as different. The school is different because children are bound to attend school. Children must look at the walls. It is absolutely insidious to think that a child would not look with reverence at the walls that they are before every day, each and every day of the school year. And I can tell you that as a mom and as a mother of a child who loves school and views school as a place where she is welcomed, where she is celebrated for all of her difference and for all of her talents, this is something that we do not want to advance. It is not that we want to disparage the Christian faith. It is not that we want to say that the Christian faith does not propose or espouse values or morals that we all hold dear. It is to say that other religions have their own values that they espouse and they believe are equally good, and that those should be respected and honored. That is what we are saying. We are saying that we must not insult the intelligence of the everyday American to suggest that we don't know that this is in fact indoctrination. We must not treat our schools as bully pulpits. We must not treat our children as pawns, and we must in fact respect the dignity, humanity, compassion, and empathy that I believe that all of our school teachers have for our children, because I have had many school teachers come up to me and tell me, what do we do if in fact these posters are placed on the walls? How shall we instruct our children? How do you think we should interpret this? And I cannot tell them that. And this court cannot tell them that. The state cannot tell them that. That is for them to determine with their God and with their parents and with their families. And finally, I think it is absolutely absurd that our governor said that either people should learn the Ten Commandments or they should learn the criminal code. How dare he? It is absurd and it is insulting. Our state, unfortunately, prioritizes criminal prosecution over individual liberty and dignity. That is preposterous in this day and age. We should not suggest that people should be criminalized if they don't believe as we believe. And that is the slippery slope that we are on. Let us not go down that route. Let us not, as people of faith and people who practice perhaps no faith at all, or perhaps practice no religion, but still have their own faith, whether it be the universe or whatever you want to call it, let us not go down that path. We have a choice. We have a choice as brothers and sisters, that we can come together and we can recognize our own individual liberties, and we can stand shoulder to shoulder, recognizing our differences and respecting those differences and finding the common thread that I believe ties all religions together. It is love. It is empathy. It is compassion. It is truth. Let us stand on those values today. And we pray that the court will, in fact, uphold those.
The judges today seem kind of skeptical, or they ask skeptical questions about whether whether that could be considered establishment of religion in that culture. Can you talk about why having these posters is what's wrong with having a display?
Well, sure. I mean, I'll just say one statement, then I'll let my colleagues speak. I mean, I think it really lies in the fact that we know that schools are different and that children are required to attend schools and that children are in these classrooms. Children attend school for longer than they are at home. Any parent knows that. You see your child less during the week than you would at any other time of the day because they are, in fact, in school, they are receiving an education, and they are being taught and they're being molded and they're being shaped in the ways that we've all agreed are appropriate. What we have not agreed is appropriate is for our children to be molded and shaped with religious doctrine that may be different than what their families choose for them. And the Supreme Court recognizes that schools are different. They're different than a building like this, like a courthouse where there may be a statue. They're very different. And children are children are sponges. Children are very, very vulnerable to all kinds of pressure and, in fact, coercion. And I think right now we're talking about semantics with our language of passive versus active. If you put something in front of a child and suggest that they won't read it when they're fully capable of doing so, I think that's an insult to all of our intelligence.
Yeah, and part of this is the ubiquitous nature of these displays. They are required to be in every class: French class, math, Spanish, anything, music, classes that have nothing to do with anything posted on that sign. And we've heard politicians tell us what kids should believe, what religion kids should believe, and that's absurd. We know that the Ten Commandments are sacred to many people, but they are not sacred to all. And there are many appropriate ways and appropriate places, times and places, where you can use the Decalogue, but we leave those decisions up to parents and families. We do not leave it up to government bureaucrats to decide what is religious truth that should be taught to students every day that they are in public school.